There's nobody out there that couldn't hear me, huh? Thank you. So just a reminder, we are recording and we're broadcasting live, so please do not disclose any confidential information over the phone. And if you wish to receive credits for CMEs or CEUs, please announce yourself in the chat box or over the phone towards the end of the presentation, and we send those out toward the beginning of the following month. These icons right here on Zoom are the way you're able to join audio and video. These are our disclosure and accreditation statements. We do have case consultation reimbursement opportunities through Molina and Blue Cross. If you're interested, please contact myself, Zach Johnson, or my supervisor, Kevin Werling. Our contact information is presented at the end of these slides. And I guess we can take this opportunity to introduce everybody in the room if you'd like.
Yes. So, Zach.
I'm Mari. I'm a second-year pediatric resident at UNM.
I'm Jane Zeckley. I'm a nurse practitioner with Fronteras at Envision, New Mexico.
My name is Maya Trujillo. I am a quality improvement specialist here at Envision.
Hi everyone, good morning. My name's Emma. I'm an MSW student here at Envision, New Mexico.
I'm Jennifer. I'm a fourth-year medical student at UNM.
And I'm Jessica Martin.
Okay.
All right, so with that, I'll hand it over to our facilitator, Carol.
Good morning, everybody. It's Carol Conley here at Envision, and welcome back to Studio Envision for the remainder of our Adolescent Health Initiative. Today, I am happy to introduce Jessica Martin. She's going to speak to us about supporting immigrant and refugee status adolescents. And Jessica is an attorney at the New Mexico Immigrant Law Center, a nonprofit organization offering free and low-cost immigration legal services to New Mexico residents. And I wanted to make sure you knew that. She put her contact up there so that you could reach her if you have any challenges that come up after her presentation. Ms. Martin primarily represents victims of domestic violence, victims of violent crimes, and children who have experienced abuse and neglect who are at risk of removal. Ms. Martin graduated magna cum laude from the University of New Mexico School of Law in 2012, where she received the Margaret Caper Daly Award for Social Justice. She was admitted to the State Bar of New Mexico in 2012. Before entering law school, Ms. Martin worked for many years as an immigrant advocate at Southern Arizona Legal Aid in Tucson, Arizona. She is the past chair of the New Mexico State Bar's Children's Law Section. And thank you for joining us today and your willingness to give this presentation. We appreciate it.
Thank you for inviting me. So today we're going to talk about different forms of immigration status so that in all of your practice when you're working with adolescents who are immigrants, or you may even have mixed status families, perhaps the youth you're working with have status but their parents do not, you have more in your toolbox to figure out if there's anything you can do beyond what is generally in your field to help the family reach out for services, to identify if there might be legal remedies for immigration status. So I wanted to start off just in thinking about your practice thus far. And if there's ever been a time that you felt that your work was limited by the immigration status of the adolescent or family that you were working with. Was the care that you thought was appropriate or the needs that the family had in some way limited by barriers because the family or the youth was undocumented? And I want to just I'm going to pause for a few seconds to think about a time in your practice if that's come up for you. And if you want to jot down a few notes, we'll come back to this later in our discussion. So just take a minute to think about it. I'll pause for a minute and we'll go on with our discussion. One of the things that I want to do during this discussion too is let you know what types of immigration status may have greater access to public benefits and Medicaid. I know that that's something that's very relevant to the work that all of you do. And so as we go through different forms of immigration status, I'll bring that up to just kind of help to when you're in those situations where you're confronting barriers, thinking about how you can maybe tackle those. Let's go on. Sorry, I forgot to put the slide forward earlier. So there was our reflective piece. So I just want to make sure we're all starting off on the same foot in terms of immigration status. There are those who are without status or undocumented, and these could be people who came into the United States with a visa and overstayed a visa, or someone who came into the United States without any documents and now are here without lawful status. From there, there is what's called deferred action, which is not actually a legal status, but is a form of protection against removal. Deferred action has gained a lot more, knowledge due to the Deferred Action for Childhood Arrivals program that Obama put into place in 2012. So deferred action is much more common now than it has been in the past. A person with deferred action can request a social security number, and they have a work authorization. It does not lead, however, to a permanent form of status. Next, we have immigrants who are in lawful status. So this includes lawful permanent residence, which is the most stable form of immigration status before becoming a U.S. citizen. Also, asylees, refugees, and U or T non-immigrants, and we'll go over what all of those are also immigrants who are in lawful status. Some of those statuses, for example, U and T non-immigrants, they're a temporary status. The person that would have to take other steps to have a more permanent lawful permanent resident status. Others, such as lawful permanent residents, asylees, and refugees, those are more permanent long-term types of status. And then finally, immigrants, once they're lawful permanent residents, after a certain amount of time, can apply to become U.S. citizens, and they are naturalized U.S. citizens. And that's different than someone who's born in the United States. Anyone who's born in the United States is automatically a U.S. citizen. It doesn't matter whether your parents are U.S. citizens or not. And then there are also children who are born abroad to U.S. citizen parents who can acquire U.S. citizenship. So there are some youth who may have been born outside the United States who are actually citizens, even though they weren't born in the United States, and that has to do with their parents being U.S. citizens. Any questions about forms of immigration status? Okay, great. All right. I wanted to just touch on general eligibility for public benefits because I want to weave that into our discussion today. As a general rule, undocumented immigrants are not eligible for public benefits. There are some exceptions. WIC, EMSA, and meal programs at schools. Immigration status, lawful immigration status is not required for those programs. Generally, undocumented immigrants are not eligible for food stamps, cash assistance, and Medicaid, though there are some exceptions. Immigrants who are in qualified status are eligible for certain benefits, and those include refugees, asylees, battered women and children, and we'll go into more of what all of these mean. There's also in the resources slide at the end a link to a chart that the New Mexico Center for Law and Poverty has put together in which all immigration statuses are broken down, and they have tabled out which type of benefits different categories of immigrants are eligible for. And I think it includes everything from cash assistance to child care to LIHEAP, the whole gamut. So that's a very helpful chart, and there is a link on the resources page at the end of the presentation. Generally, lawful permanent residents are eligible for public benefits, but some programs have a 5-year wait period. So someone who gains lawful permanent resident status, new if it's generally an adult person who hasn't gained their status through some kind of humanitarian form of relief, maybe it's through a family petition, generally they'll have to wait 5 years before they're eligible for public benefits. But youth, and then some other categories, pregnant women, lawful permanent resident status alone will be enough, and there may not be a 5-year wait period. And again, the chart does at the New Mexico Center for Law and Poverty does a very good job of breaking that down. All right, so if you remember anything from this presentation, this is the slide I want you to burn in your brains. These are 5 questions that you can keep in mind to ask children and families, or just to even think about with children and families who you know don't have lawful immigration status. So think back to a moment when we had the moment of reflection in the beginning about the youth or family that you've worked with where you encountered some barriers due to their immigration status. And we're going to go through each of these questions, and then I'll go into more detail on the types of immigration relief. But these 5 questions will get you to most of the avenues for lawful status here in the United States. The first, does the child you're working with have a parent with lawful status? And we'll go into family immigration briefly. Does the child live apart from one or both parents? And if so, is it because the child's been abused, abandoned, or neglected by one of the parents? Number 3, is the child or the child's parent a victim of domestic violence? And if so, by whom? 4, has the child or the child's parent or sibling been a victim of a crime or human trafficking in the United States? So victims of crime and victims of human trafficking have remedies to gain lawful status. And then finally, is the child a refugee, or has the child fled persecution in the child's home country or country of origin? If you keep these 5 questions in mind, you'll be able to identify if children have a possible option for lawful immigration status. Sorry, pressed the button too hard. All right, so potential paths to legal status, basic family immigration. So our first question that we wanted to keep in mind was, does the child have a parent with lawful status? So in immigration law, a child is an unmarried person under the age of 21. So actually goes up past the age of majority. So if you're working with young adults, there's still a possibility that their parents might be able to petition for them. A parent who's a lawful permanent resident or a U.S. citizen can petition for their foreign-born children so that their children can become lawful permanent residents. There are a lot of barriers in the process. If the child's last entry was without documents, it's quite possible the child would have to leave the country and go through a consular process in their country of origin to immigrate through their parent. There are also a lot of immigration offenses for people who have entered multiple times, even if it is with a visa. So there are some barriers. Immigration has some particularly strict rules about entries and exits and people accumulating what they call unlawful presence in the United States. And you'd be surprised how many families are limited by these offenses and don't have avenues toward legal status. They would otherwise be eligible. Child has a parent who is even a U.S. citizen in some situations, but if that child's entered multiple times without documents, the child might have a permanent bar and never be able to immigrate through their parent. So the immigration laws are very strict about certain things. So that's one of the biggest barriers. There's also the filing fees alone for these types of cases when you're immigrating through a family member are $1,500 or more just for the application. So imagine if you're a permanent resident parent and you have 3 children who are born outside the United States, just to file applications, you're talking upwards of $4,000. That doesn't include if the family needs an attorney, if there are any complications in the case, that's of course thousands of dollars more, unless you can find free or low cost services. So when you're working with adolescents who are undocumented, who do have a parent with lawful status, of course we need to identify that. And the family needs to know that they need to try to do something before that child turns 21. When the child turns 21, the wait period to immigrate through a parent changes from about a year to 2 years to over 20 years. The backlog for adult children immigrating through their parents is incredibly long. So for something for you to keep in mind for your practice, really important to catch youth before they turn 21 if they have a parent with lawful status. For children to become naturalized citizens, so if they become a permanent resident through their parent, they need to be a permanent resident for 5 years before they can apply for U.S. citizenship, and they need to be 18 years old. So that's something else to keep in mind. Something that's not on the slide that can be helpful, there are some situations when a U.S. citizen parent that immigrates their child to permanent resident status, that child may automatically become a citizen through the Child Status Protection Act. So there are some situations in which a U.S. citizen parent who immigrates their child who's under 18 and that child becomes a permanent resident, they automatically become a citizen. There is a form that they have to file to get a certificate of citizenship, and that form also costs around $1,000, but there are fee waivers available. This could come in handy if you're thinking about if the child has any limitations on getting public benefits because of that 5-year wait period that we talked about. In some situations, if you can recognize that this child may automatically be a citizen because one of their parents is a citizen. They just gained permanent resident status. We have this hold up on whether or not they can receive benefits at this time. This might be a hurdle over that. I think most children who are permanent residents who are under 18 qualify for Medicaid. I don't think there's a wait period, so it probably won't come up very often in your work, but if it does, that's something more to think about.
Quick question.
Yes.
When you say parents, are they only birth parents, or could a U.S. citizen be in a relationship and adopt a child?
Yeah, so there's a couple of different step parents can also immigrate their stepchildren as long as the marriage took place before the child turned 18. And then, yes, adoptive parents can also immigrate immigrant children that they've adopted. The rules are slightly different, and there's a couple more requirements, but that is a possibility. All right. Next, we're going to talk about special immigrant juvenile status. And this is actually one of the forms of relief that you're most likely to come across as an option. Originally, special immigrant juvenile status was envisioned for youth who were in the foster care system, who had experienced abuse and neglect. And before 2008, one of the requirements was actually that the child be eligible for long-term foster care. But in 2008, the law changed to allow children who were abandoned, abused, or neglected by only one parent to be eligible for special immigrant juvenile status. So this had a huge impact. Unfortunately, in our nation, we have a lot of children who've been abandoned by a non-custodial parent. That parent isn't involved in their life at all. The parent's not paying any child support, is not in communication at all with the child. That child, for purposes of special immigrant juvenile status, can be considered an abandoned child and may be eligible for special immigrant juvenile status. This has huge impact because special immigrant juvenile status is a pathway to permanent status, to permanent resident status that we talked about as kind of that most stable immigration status before becoming a U.S. citizen. Special immigrant juvenile status also leads to immediate eligibility for Medicaid. So the moment the application's filed, the child under the New Mexico Administrative Code becomes eligible for Medicaid. They don't even have to wait for status. When you're working with different public benefits agencies in New Mexico, most workers are not familiar with this provision of the New Mexico Administrative Code, and so there will often be advocacy that's needed for the child to actually enroll in Medicaid. But special immigrant juvenile status has the potential to change a child's life pretty quickly. So if you know that a child is only living with one parent, or perhaps isn't living with either parent, they're living with a grandparent or an aunt, these should be little triggers in your mind. Could special immigrant juvenile status be an option? It's a bit of a complicated process. A state court actually has to make findings about abuse, neglect, or abandonment. So it's not just fill out a form, file it with U.S. Citizenship and Immigration Services, and the kid's good to go. It definitely will require at least one attorney, an immigration attorney, and perhaps even a family law attorney to do a kinship guardianship if the child is living with a non-parent, or a sole custody case if the child's only living with one parent. So it is a complicated form of relief, but the number of children, immigrant children who are likely eligible for special immigrant juvenile status is very high, unfortunately, because we have a lot of children who are growing up in single parent families or being raised by relatives. Let's see. I think the only other thing I would add on special immigrant juvenile status is we go back to that same definition of child. So a child is someone who's unmarried and under the age of 21. However, most of our state laws limit the definition of a child to under the age of 18. So for example, in a kinship guardianship, if a relative's raising the child, if that child's already turned 18, they wouldn't be eligible for kinship guardianship, and it's very unlikely we'd be able to do a special immigrant juvenile status case. So this is one of those forms of relief to keep in mind where we really need to catch the child before the child turns 18. Potential paths to legal status, the Violence Against Women Act, VAWA. A child who has been battered or subject to extreme cruelty by a lawful permanent resident parent or a U.S. citizen parent or step parent may self-petition for their own legal status. So this kind of takes the place of the family petitioning process. We talked about in the beginning how a U.S. citizen or lawful permanent resident parent could immigrate their child. In the 1990s, Congress passed the Violence Against Women Act, where Congress recognized that a child who's being abused by a parent, that parent is very unlikely to petition for them for lawful status. VAWA is also for spouses of permanent residents and U.S. citizens who are being abused by their spouse. And again, it's that same idea that this would be someone who'd be eligible for a family-based immigration petition, but it's very unlikely in a situation of power and control and abuse and domestic violence that the partner with status is going to file an application. Very unlikely. It's part of the power and control. So the Violence Against Women Act allows children who are abused by their U.S. citizen or permanent resident parent, or spouses who are abused by U.S. citizen or lawful permanent resident spouses, to petition for their own status. They get a protection against deportation, that deferred action, and a work permit. They're also considered qualified immigrants for public benefits purposes and federal financial aid. So again, this is one where when you're working with youth, if they do qualify for VAWA, or if their parent is a victim of domestic violence and qualifies for VAWA, children can be included on that application. And once that petition is filed, they'll get a prima facie notice letting them know it looks like they meet all the requirements. With that initial notice, they'd be eligible for public benefits. So again, access to Medicaid pretty quickly with this form of relief. And it is a path to permanent status, permanent resident status, and citizenship. Crime victims. There is what's called a U visa, which is a temporary form of status for someone who's been the victim of certain crimes in the United States. If that person's been helpful in the investigation or prosecution of the crime and has suffered some kind of substantial abuse as a result of the crime. Most of the crimes that are qualifying crimes for U visas are violent crimes. Domestic violence, felony level assaults, kidnapping, false imprisonment, abusive sexual contact, rape. But then there are also some kind of rarer crimes that are not related to violence, such as witness tampering and some other related crimes. So if you encounter someone who's been the victim of a violent crime and they're undocumented, it's very possible that they could be eligible for a U visa, and you should refer them to one of the nonprofits in New Mexico. Those nonprofits are listed at the end of the presentation on the resource slide for a consultation to see if they might have an avenue for status. U visas, unfortunately, they only grant 10,000 a year. And right now there are more than 100,000 cases pending with U.S. Citizenship and Immigration Services, which means that the wait for an actual U visa could be a decade or more. After several years of having your case pending, U.S. Citizenship and Immigration Services is granting deferred action and a work permit while people wait for their actual U visa. But there's very limited access to public benefits during this process. So while the U visa may lead to eventual status for a family, it's not something in your practice that will immediately help you with access to Medicaid or public benefits. Trafficking victims. There's a T visa for people who have been victims of severe forms of human trafficking, such as sex trafficking or labor trafficking. Sex trafficking requires a commercial sex act, which is induced by force, fraud, or coercion. There's an exception for victims who are under the age of 18. You do not need to show the force, fraud, or coercion. The premise is that someone who's under 18 couldn't consent to that type of sexual activity and hence doesn't need to show force, fraud, or coercion to be eligible for
T visa status. Labor trafficking involves some kind of forced labor. So if you're working with someone who says, I have an employer who hasn't paid me, and they say if I don't like it, I can, just leave my job and lose my job. That's not labor trafficking. That's certainly, violation of labor laws, but it's not actual forced labor. We're looking at situations here where the person's not free to leave their job. Perhaps the employer has threatened them that if they don't do, 7 shifts in a row, that they're going to call immigration on the person, and the person feels like I have to work all these days. I'm exhausted. I can't work 7 days a week, but I've been threatened by my employer, and I feel like I can't leave my job. That's where we get into more of a labor trafficking situation. Immediate family members can be included. So again, this is one where it may be the parent that's identified as a possible applicant for a T visa, and they could include minor children who are undocumented, or actually children under 21 who are undocumented, unmarried. Anyone who is in T visa status is a qualified immigrant for public benefits. So very good access to public benefits, and wait times for this type of application are not very long, usually less than a year. I also wanted to mention asylees and refugees. Refugees are granted refugee status outside the United States, and then enter the United States in refugee status and already have access to public benefits pretty much upon arrival. Asylees are those who enter the United States fleeing persecution in their country of origin and apply for status once they're here in the United States. Asylum is very hard to win in our particular circuit. New Mexico is in the circuit for immigration law with Texas, which has very conservative case law. And the judges in El Paso who hear any removal cases from the state of New Mexico, their approval ratings on asylum cases are less than 2%. So less than 2 in 100 people are approved for asylum. So in our state, in New Mexico, asylum is not a very good option for people. New York and California have very high approval ratings of more than 60%. So just where you live greatly impacts whether or not you could be granted a status as an asylee. These are not different cases. It's not that New Mexico gets weak cases and other states get strong cases. These are the same situations. People are fleeing the same types of persecution in the same countries. And the geography and politics of a particular circuit greatly impact access for people to asylee status. Another type of status you might run into is parole. It's usually a little white card that has a person's picture on it and a stamp, and says that they've been paroled in the human interest or public interest for sometimes as much as a year or more. I only bring this up because someone who's entered the country recently requesting asylum may have been granted parole only to enter while they fight their asylum case, but there are provisions for public benefits for people who have parole of 1 year or more. So there may be access to Medicaid for someone who's been granted parole. Another thing to keep in mind if you're working with a lot of refugee families, refugees who don't become U.S. citizens within 7 years will lose their benefits, including SSI and Medicaid. So if you're working with a refugee family, important to encourage them to apply for permanent resident status and U.S. citizenship as soon as they're eligible. After 1 year in refugee status, a person can apply for their permanent resident status, and then after 5 years in their permanent resident status, they can apply for citizenship. This can also help children. We talked about in the beginning how certain U.S. citizen parents who have lawful permanent resident children under age 18, those children could automatically become citizens. This happens a lot in refugee families. If the parent becomes a citizen, the children under 18 automatically become citizens. So if you have children who are in refugee families who are at risk of losing their benefits, something to look at, they may automatically be U.S. citizens if one of their parents has already gained U.S. citizenship. Deferred Action for Childhood Arrivals is the program that President Obama put in place in 2012. At this time, as of February of 2018, it is only U.S. Citizenship and Immigration Services is only accepting renewal applications. So at this moment in time, based on various court injunctions, and current policies, if someone has ever had DACA before, they can apply to renew, but anyone who's newly eligible cannot at this time file an initial application. So if you have someone who had a DACA work permit at some time, they can at this moment apply to renew that. DACA does not afford access to public benefits or Medicaid, but it does give young people employment authorization, a social security number, and some protection here in the United States. Okay, so now what can you do for immigrant adolescents? This is just kind of a little recap, something to think about in your work. Now that you have had this introduction to some of the more common forms of relief for adolescents, identify youth and their parents who may be eligible for lawful or more permanent immigration status. So using those questions in the beginning, keeping that framework in mind. If you do encounter someone who you think, and this is for all of you who are practicing in fields of medicine or social work, you don't feel like you need to assess the family's actual eligibility. If you can just catch a little red flag of, oh, this person mentioned that they'd been a victim of a crime recently, I remember something about this. Refer them to one of the legal service agencies to get a full evaluation. You're not expected to do the full analysis yourselves. I just hope that there's some little things in your head where you can think, oh, there might be some option available here. So referring them to immigration legal services or experienced private immigration attorneys. Encouraging youth to seek legal advice before turning 18. Remember we talked about with special immigrant juvenile status, our state laws limit most of the SIJS cases to under the age of 18, some if they are 18 already, but good to catch those early. Youth also need a lot of support through the immigration process, especially if parents are unable to assist for some reason. Imagine just for those of us who are educated and professionals, how many of us are just like, oh, I'm going to go see a lawyer, just going to look one up and go show up at the lawyer's office. It can be daunting. It can be intimidating. If you're not familiar with the legal system, if you're an adolescent, they may need support in calling to schedule appointments, actually arriving at appointments. So anything that you can do in your field, whether it's connecting the youth to social workers and others who can support them in the process. And then coordinating services to ensure that they actually do get their increased access to healthcare, public benefits, and education. As I mentioned with special immigrant juvenile status and that kind of immediate eligibility for Medicaid, not very well known among those who enroll for Medicaid, and so definitely need some kind of coordinated services to ensure that youth actually have increased access to the benefits they're eligible for. All right, we're going to go back to our reflective piece and thinking about the youth that you wrote about in the beginning or thought about in the beginning of the presentations. Now, after hearing some of this, what are some of the questions that you might ask the youth or the family, immigrant family that you were working with? Was there anything that came to mind of, oh, this is something I would have liked to have asked them, or something I'd like more information about to see if this family might have some options? And open it up if anyone has anything that they want to share or ideas.
The thought about single parent families, that you know, thinking that they may have been abandoned or whatever, and there's just one parent and the other one's gone, maybe makes it easier, or at least that's a foot in the door to start. And I hadn't connected that.
Yeah.
You know.
And it impacts a lot of children. It's
Yes.
a possibility for a lot of undocumented children.
And then if there's any way we could separate that court from Texas, that'd be so.
I know, for asylum seekers. Yeah. We actually have had recently, there was the Cibola County Correctional Center started accepting immigration detainees in late 2016. And they assigned the Denver court to that facility, which was actually much better. So we did have some people who were detained in Cibola who were actually winning their asylum cases because the judges there had upwards of 35% or higher approval ratings. So yeah, there was some benefit there, but they've since reassigned most of those cases back to El Paso. Was short-lived.
And then a question I had, and I don't know that you would know the answer to this, but we work a lot or connect with Pegasus Legal Aid do they ever do this kind of work for the youth? Just because I know that they can be no cost or really low cost.
Yeah.
And so is there anybody there that would advocate for these kids? Okay.
Yes, and they do have training on special immigrant juvenile status, which is the form of status for children who have been abandoned, abused, or neglected by one parent. And I collaborate with their staff pretty frequently in cases where they're doing a kinship guardianship for an undocumented child. They've done some emancipation cases for homeless youth who would be eligible for special immigrant juvenile status. So they definitely are aware of this form of relief, and we have a special immigrant juvenile status working group among different legal aid agencies to make sure that these legal services are available to you.
Great. Okay.
All right. In reviewing these forms of relief, which types of immigration status afford the most access to healthcare, public benefits, and higher education, and which the least? Anyone want to take a stab at that, or I can just give you the answer?
Well, I was thinking it was the permanent resident status gives you the most.
Yes. Yeah.
And the least.
Well, being undocumented gives you none.
None, exactly. Undocumented gives you none. For
the other options.
Yeah, and deferred action in
Really
most cases gives
deferred
very
action.
little.
Okay.
Yeah. It's not an actual legal status. But the Violence Against Women Act protections, asylees and refugees, they're all considered qualified immigrants in addition to lawful permanent residents. And so they would have the most access to public benefits. And again, as we'll see on the resource slide, that chart is there from the New Mexico Center for Law and Poverty. So if you ever want to look it up, it's very comprehensive and goes into the different forms of immigration status and access to public benefits.
And the Center for Law and Poverty is where you said that table is available, right? That explains the benefits and how they're laid out. That's great.
And then here's the resource slide. And so it's the second link down there. very good description of eligibility for public benefits. Right below that is the site for Medicaid eligibility, and it's several pages into that particular section of the New Mexico Administrative Code, but it is in there where the applicants for special immigrant juvenile status are eligible for Medicaid.
Okay.
And then free and low-cost immigration legal services are there. I'm with the New Mexico Immigrant Law Center, some other nonprofits in New Mexico that provide free or low-cost immigration services, the Santa Fe Dreamers Project, Catholic Charities of Central New Mexico that has office here in Albuquerque, and then Catholic Charities of Las Cruces that has an office in Las Cruces.
Thank you.
Yeah.
That's very informative.
Yes.
Anybody else around the table have any questions or comments for Ms. Martin? Anyone out in Zoom land? Any questions? Okay. Well, if we have no more questions or comments, we can call it a day and everybody go have a fabulous Wednesday, and we'll see you here next week.
Carol, question from Sandra. How would a serious mental illness impact eligibility?
That's a good question. There are some forms of relief where having a serious mental illness that has associated dangerous behaviors could make someone inadmissible for permanent resident status. There are a lot of waivers, and if you can show that the serious mental illness is not at this time causing dangerous behaviors that could endanger the person or others, it may not be an issue at all. But there is a possibility that it could impact the person's ability to become a permanent resident. For most of the other forms of humanitarian relief that we were talking about that are kind of precursors, types of status that you get before you actually can apply for permanent residence, for most of those, it would not matter if the person had a serious mental illness. You could still apply under the Violence Against Women Act. You could still apply for a U visa. A child could still apply for special immigrant juvenile status. The barrier might come up later when they're applying for their permanent resident status.
Okay. Thank you, Sandra, for the question. Yeah. Anything else in the chat box?
Thank you. So Sandra.
Okay.
Thank you, everyone.
Thank you.
Thank you.
Have a great day, everybody. Thank you very much. That was very interesting.
Yeah, that was great. I learned a lot.
I know. So we can take with us in this funky political climate too, where